Sometimes an event happened in our society leaves a very big scar in this society. And sometimes the same very bad incident also leads to a lot of good changes. And one such very big bad scar and the case which led to a lot of changes in criminal law in India was Nirbhaya's case. Yes, Nirbhaya's case shouldn't have happened. It left a very big scar on this society. But then two big amendments came after that, 2013 and 2018 Criminal Law Amendment Acts. And they brought a lot of changes on criminal laws in India. And one such big amendment was Section 166A of IPC. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Indian Penal Code, we are focusing on Chapter 9, which is all about offences by or relating to public servants. In this series, this is my second video where I am going to focus on an amendment section, that is Section 166A, which focuses on public servant disobeying direction under law. Though the section says public servant, it is all focused on police officers. This is one of the very important section, and that is why I have kept an independent video for this, and I have done a lot of research before I do this video. I wanted to give a comprehensive approach for this particular section, so I have made it little lengthy so that you have every information available, but at the same time I have tried to keep it in a minimal time frame to ensure that this is worth of your time. With that, I am taking you to slide number 1. Let's try understand the Bare Act provision and then the chart. Then I will break it into pieces and explain every single aspect of section 166A, because every single aspect of 166A is very important and worth studying. Let us start understanding the section by reading the Bare Act provision first, and then I will take you through the chart, and we will also discuss few other very important sections from CrPC which we need to understand while understanding section 166A. Section 166A, as I said, discusses about public servant disobeying direction under law, and when we are saying public servant here, it is mostly of a police officer. That is one another aspect we need to remember. And the Bare Act provision says, whoever being a public servant, A, knowingly disobeys any direction of the law which prohibits him from requiring the attendance at any place of any person for the purpose of investigation into an offence or any other, or B says, knowingly disobeys to the prejudice of any person any other direction of the law regulating the manner in which he shall conduct such investigation, or C says, fails to record any information given to him under subsection 1 of section 154 of the Code of Criminal Procedure 1973 in relation to cognizable offence punishable under section 326A, section 326B, section 354, section 354B, section 370, section 370A, section 376, section 376A, section 376B, section 376C, section 376D, section 376E, or section 509 shall be punished with rigorous imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years and shall also be liable to fine. This is what section 166A says. Now let's make it easy with the help of my chart, and we also need to understand few other very important sections, especially from CrPC. Let us try understand them also, along with few other very important sections that we need to keep in your mind while reading section 166A, that is from IPC. All of that will be discussed before the end of this session. Let's get into the next slide. Section 166A, which discusses about public servant disobeying direction under law, has 3 important subclauses in it, and if you closely observe it, you are finding 3 very important ingredients from these clauses. In clause A, you are reading about attendance. Under clause B, you are reading about investigation. And under clause C, you are reading about recording. Now, these three, that is attendance, investigation and recording, or in simple words, we can call them AIR, AIR. Now, these three words are the major ingredients of section 166A, and if we understand them, in that case this particular section becomes very easy. Under clause A, a public servant is forcing attendance of someone if he or she does so. A police officer forcing attendance of someone which is against law, in that case that becomes a punishable offense. Forcing whom? Forcing very young, or forcing very aged, or forcing someone who is mentally or physically disabled, or forcing a woman. All of these are offense. Now where are we studying this? Under section 160 of CrPC, which I am going to discuss later also. So basically under clause A, what you need to remember, if a public servant forcing attendance of someone against the law, in that case that is a punishable offense. That is what you need to remember under clause A. Under clause B, what are we understanding? There, if a public servant does illegal investigation or prejudiced investigation. Now where are we discussing investigation under CrPC? Under CrPC chapter 12, we are discussing about information to police and their powers to investigate. There we have sections starting from 154 to section 176, which are all about information to police and their powers to investigate. Now there, like for example, if it is a cognizable offense, in that case a police officer can start investigation without the orders from magistrate. But if it is a non-cognizable offense, he cannot do so. All of that are very clearly mentioned under CrPC. If knowingly a public servant disobeys all of this and start a prejudiced investigation or illegal investigation, in that case that is an offense punishable under section 166A. The third part is failing recording. Now if any public servant fails to record any information given to him under subsection 1 of section 154 of CrPC. Now here there is a big list of offenses which he need to make record as per section 154 subsection 1 of CrPC. What is that? I will explain in my next slide. But what are the offenses he need to record? I have given the list of all those offenses which are mostly are the offenses against women or against vulnerable group. Like for example, 326A discusses about voluntarily causing grievous hurt by use of acid. 326B, voluntarily causing grievous hurt by use of acid. 354, assault or criminal force to women with intent to outrage her modesty. 354B, assault or use of criminal force to women with intent to disrobe. 370 is trafficking of person. 370A, exploitation of a trafficked person. 376, punishment for rape. 376A, punishment for causing death or resulting in persistent vegetative state of victim. 376B, sexual intercourse by husband upon his wife during separation. 376C, sexual intercourse by person in authority. 376D, gang rape. 376E, punishment for repeat offenders. 509, word, gesture or act intended to insult the modesty of a woman. All of these cases need to be recorded by a public servant as under section 154 subsection 1. Now what is 154 subsection 1? I will discuss in detail in my next slide. But remember, if a public servant is failing to record this, in that case that is also a punishable offense. And what is the punishment here? Such offences shall be punished with rigorous imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years and shall also be liable to fine. So basically what we need to understand, if a public servant forcing attendance of those who should not be forced to be there in the station as discussed under section 160 of CrPC, then he is punishable. Or if he or she is conducting illegal investigation or prejudiced investigation, that is a punishable offense. Or if he or she fails to record as under subsection 1 of section 154 of CrPC, the list of offenses that there is already given under 166A also, in that case such is a punishable offense. All of these are punishable offense. Here we need to understand two very important sections from CrPC, that is section 154 of CrPC and 160, which I am going to discuss in my next two slides. While reading section 166A, subsection 1 of section 154 of CrPC plays a very important role. Section 154 of CrPC discusses about information in cognizable cases, and subsection 1 reads, every information relating to the commission of a cognizable offense, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. Now this is the requirement, and every public servant who is a police officer shall do it. That is what section 154 subsection 1 says. Now here one another important aspect, if there is any confusion as to territorial jurisdiction of a crime, in that case 0 FIR should be recorded whenever we are discussing about all these sections which we discussed in our earlier slide, as well as here also there is subclause A, B, C available for subsection 1. You can read through there, all the sections are mentioned again, and they need to be recorded, they need to be videographed. All of that is coming further in section 154. You can read through, but remember these are very important recording procedures, especially when the crime is against women or against all those trafficking person, all of that. So that needs to be completed, which is what one of the important work to the public servant. And if such public servant, that is police officer, if he or she is not completing that, then it becomes a punishable offense. That was subclause C of section 166A. The one another important aspect, that attendance, we read in the subclause A of 166A, which I am going to explain in my next slide. The class will continue. In between, I just wanted to share an important update with you guys. I have joined the Unacademy team as an educator for CLAT 2023 batch, and I would like to request you all to download the Unacademy app and follow me there also. And while buying the subscription over there, please buy the subscription with my code GYAN07, that is GAN07, to get additional 10% discount. And what's happening in Unacademy this week? A 6 months comprehensive batch for CLAT 2022 is starting on 24th November in the name of Excel Law. And a 1 year comprehensive batch for CLAT 2023 aspirants starting on 26th November in the name of Gavel Makers. And a 30 days crash course for LSAT 2022 is starting on 26th November in the name of Let's Crack LSAT. Now you can all join all these classes, and while buying the subscription, please use my code, that is GYAN07, GAN07, and most of my classes are happening at 6:45 p.m. on daily basis, and I'm requesting you guys to join there also. Thank you. When it comes to attendance, we need to understand CrPC Section 160, which discusses about police officers' power to require attendance of witness. There is a proviso which very clearly says, provided that no male person under the age of 15 years or above the age of 65 years, or a woman or a mentally or physically disabled person shall be required to attend at any place other than the place in which such male person or woman resides. Now this proviso is available. That is what I have mentioned in red and green fonts. Now red means those persons cannot be called to police station, and where will be they inquired? If required, they will be inquired at the place in which they are residing. That is what the law says, and hence a public servant cannot force their attendance in the police station or any other place other than where they are residing. Okay, they need to go to the place of such persons residing, and there they can do investigation, and they cannot force their attendance in any other place other than their residence. That is what we need to remember when I say their residence. Such person's residence, not the government official's residence or police officer residence. It is in the place where such person is living. The person who is below 15 years or above 65 years, who is a male or a woman or a mentally or physically disabled persons, none of them can be called to any other place other than the place that they are living. That is what we need to understand when we are discussing section 166A clause A. Okay, when we are reading about forcing attendance. I hope that is very clear. With that thinking, I am handing over this presentation to Nishan.
With that, I am concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.